If you're watching this and you have a green card, TPS, a pending case, or family stuck somewhere in the system, you've probably already asked yourself a hard question this year. Is 2026 the year my case finally moves forward, or the year everything stops? Some people online are saying it's over. They're going to end immigration altogether. Others insist nothing has changed, it's all political noise. Both extremes are wrong. What I'm going to walk you through today could be the difference between moving your life forward in 2026 or getting stuck in limbo for years. We've made it into a new year. After everything that happened in 2025, travel bans, TPS terminations, delayed interviews, surprise denials, tougher enforcement. Simply being here and still in the fight is something to appreciate. You're watching Immigration Updates. Hub. I'm an immigration attorney working with clients all over the United States. In this update, I want to do something simple but powerful. Strip away the rumors. Show you what has actually changed at the start of 2026. Explain who is most affected. And give you concrete steps to protect your status and your family. Without panicking. This is general information, not personal legal advice. Your case may be very different from the examples I mentioned, so always speak with a qualified attorney about your specific situation. Let's start. Rumors versus reality, where things really stand. If you scroll social media, you will see two kinds of messages. Everything is ending, everyone will be deported, no cases are moving. Nothing is different. It's all hype and fear-mongering. The truth, as usual, lives in the middle. There must spawn very real changes that matter deeply for certain groups. There must also very real legal protections still in place that don't make headlines but quietly keep people safe. I'm going to start with some of the hardest news, then move toward parts of the system that are still working. Wins from the courts, and a real-life example of someone who walked out of removal proceedings when it looked impossible. One, Venezuela. TPS ended, travel limits, and mixed signals. Let's begin with Venezuela because that situation alone is confusing enough to overwhelm anyone. In 2025, the U.S. government formally ended temporary protected status, TPS, for Venezuelans. That one decision instantly threw hundreds of thousands of Venezuelans into a new kind of uncertainty. Many had built their lives in the U.S. under TPS, worked, paid taxes, stayed within the rules, raised U.S. citizen children, seen this protection as their main legal safety net. Suddenly, that net was cut. On top of that, Venezuela was placed on a key partial travel restriction list. Many visa categories for Venezuelan nationals became either blocked or under much extreme scrutiny. A lot of pending consular and USCIS cases were effectively frozen. Then, the situation inside Venezuela deteriorated further. The U.S. carried out airstrikes. Reports circulated that President Maduro had been captured and brought to the United States. You can imagine the shock and confusion. Does this change everything? Will the U.S. say Venezuela is now safe and deny protection? Or will they admit that things are more dangerous than ever and expand protections? Into that uncertainty, we got a contradictory public message. In one television interview, the Secretary of Homeland Security said something that sounded to many ears like hope. She suggested Venezuelans who had TPS could now pursue refugee-type protection, that they might have new opportunities to seek safety here under the changed circumstances. Those remarks were heard by thousands of frightened people desperate for still an illegal path to remain. Then, very quickly, the same department walked it back. On social media, DHS emphasized TPS was ended. The administration viewed Venezuela as more free and Yetoya more stable. Former TPS holders could now return home. So within days, we went from a senior official sounding as if a yabi door was opening to official written statements trying to shut that door again. If you're Venezuelan and you feel whiplash from this, you are not alone. Right now, the honest summary is this. TPS for Venezuela is officially ended. Venezuelans are under partial travel restrictions. Many immigration benefits for Venezuelan nationals are paused or moving extremely slowly. There is no new broad, generous program written into law specifically for former Venezuelan TPS holders. Official messaging has been inconsistent and sometimes contradictory. What this means practically, if you are Venezuelan and thinking about asylum, travel log, filing new applications, or reopening new old ones, you must base your decisions on current law, actual written policy, and real case analysis with a professional, not on a single line from a Sunday talk show. 2. The expanded travel restrictions and USCIS hold and review memo. Now let's move to a change that affects many countries, not just one. On January 1st, 2026, a new phase of travel restrictions took effect. This is not none. The small list of countries you might remember from earlier travel bans. The current framework is broader. One list of fully restricted countries, another list of partially restricted countries. Together they cover about 39 nations. For some of these countries, nearly all of visa types are blocked. For others, certain categories are allowed under strict conditions. Others are simply not available. On its own, that's a huge shift, but just as important is what USCIS did behind the scenes. On the very same date, an internal memo went out to USCIS officers. In plain language, it said, "For nationals of these high-risk countries, pause and reevaluate." The memo instructs officers to hold and slow walk the adjudication of many immigration benefit applications filed by people from those 39 countries. Apply this both to new cases and certain older pending cases. It covers a wide range of benefits: green cards, family-based and many employment-based, asylum cases, naturalization, citizenship, work permits, other humanitarian and discretionary benefits. And it does not distinguish between people who just arrived last month and people who have been living lawfully in the U.S. for 10, 15, or 20 years. If your nationality is on one of those lists, your pending case may now be sitting in a special review category, waiting for additional security or policy guidance. The memo goes further. It calls for a broad evaluation of screening procedures. For these nationalities, a review of how officers have been deciding these cases up until now. Essentially a question, under today's political and security lens, is what we've been doing enough? And then comes the part that makes many people with already approved cases nervous. The memo instructs officers to re-review certain cases that were already approved. Specifically, benefit requests for nationals of these countries that were approved on or after January 20th, 2021, the start of the current administration, including approved asylum grants, approved green cards, approved naturalization, citizenship cases. The stated goal is to see whether anything was missed, or whether, through the new travel restriction framework, some cases might have been treated differently. In theory, this re-review could lead to new interview notices, requests for additional evidence, attempts to reopen or challenge some past approvals in practice. As of right now, many attorneys are not yet seeing a wave of people being called back in. But the Kiowa Authority to re-review is now clearly written down. The agency is clearly collecting data and preparing options. If you are from one of those 39 countries, what does this mean for you? If your case is one on us pending, expect slower movement than normal. Prepare yourself mentally and practically for a longer wait. If your case was approved on or after 2021, be extremely disciplined about opening your mail. Never assume a letter from USCIS is just a duplicate notice. If you get anything mentioning re-review, additional questioning, a new interview, or a reopened case that is not the time to ignore it or try to handle it without help. This is also not the time to move without updating your address or Let important notices sit unopened in a stack of mail. In this climate, being reachable, integrous, responsive, and whenever possible, represented just can make a crucial difference. 3. Talk of an immigration moratorium in Congress. While agencies are tightening internal rules, some members of Congress are saying the quiet part out loud. They don't just want to slow this immigration. They want to stop it, at least temporarily. A member of Congress from Florida has already talked publicly about introducing legislation for an immigration moratorium. Essentially, putting most forms of immigration on hold, sometimes framed as a pause until we fix the system. In different versions of this idea, some proposals would allow only very limited tourism and business travel. Others would severely restrict even that. Will a broad moratorium like this actually become law? It would need to pass both the House and the Senate. It would need the president's signature. Even then, it would almost certainly face court challenges. We cannot say it will happen, but even bills that never become law still matter because they reveal the political mood. Among certain groups, take up huge amounts of political energy and attention, crowd out more constructive, practical reform efforts. For families waiting on petitions filed years ago, employment-based green cards, humanitarian protections, even the discussion of a moratorium can increase anxiety, make timelines more uncertain, slow momentum for positive change. 4. Where the system is still fighting back, TPS and the courts. Up to this point, most of what I've described is heavy. Now let's look at places where the system has pushed back on extreme decisions. One of the most important recent examples involves MIA's temporary protected status, TPS. When the government moved to terminate TPS for people from Honduras, Nepal, Nicaragua, tens of thousands of people who had lived and worked legally here for years, complied with every renewal, built stable lives, suddenly faced the loss of status. Those terminations were challenged in federal court. In one major case in California, a federal judge looked carefully at how DHS reached the decision to end TPS and found serious problems. The agency failed to fully consider ongoing conditions in those countries. It rushed toward termination, without following the normal, careful analysis the law requires. The judge issued an order blocking the government from carrying out the terminations for now, preserving TPS for tens of thousands. While litigation continues, in Massachusetts, a similar story played out with TPS for South Sudan. Another judge faced with the imminent expiration of TPS granted an emergency order saying, letting TPS lapse before a full court review would cause immediate, irreparable harm to people who still face severe danger if returned. In plain language, the court said, you cannot just flip a switch and push tens of thousands of people back into unstable, dangerous conditions without a lawful, well-reasoned justification. Does this mean TPS is now safe forever? No. These court decisions are often preliminary. They keep protections in place. For now, while the lawsuits move forward, a future administration or future court ruling could alter the picture again, but it does prove something important. The judiciary still acts as a check. When the executive branch goes too far or cuts corners, not every attempt to strip status or close the door survives its first encounter with a judge. 5. Detention and the limits of no-bond policies. Another area where the courts have intervened is immigration detention. There was a period where policy coming from the executive branch essentially said, if someone entered the U.S. without inspection and was picked up by ICE, they could be held without bond for the entire length of their immigration proceedings. It wouldn't matter if they had been here peacefully for 10, 15 years, had U.S. citizen children, held a stable job, had deep ties and no serious criminal history. The message was, if ICE arrests you, you stay detained until your case is completely over. No bond. When those cases reached immigration courts around the country, more than 300 judges, one appointed by presidents of both parties, looked at them and said, no, that goes too far. In over by 600 hours, more cases, immigration judges ordered people released or ordered that they receive a bond hearing. They criticized the blanket no bond approach as undermining due process, causing unjustified long-term detention of people not accused of crimes, failing to consider individual circumstances. This does by no means mean ICE detention is gone or everyone gets released. But it does mean the words mandatory and no bond are not always the end of the story. When a real case comes before a real judge, arguments can be made. Sometimes those arguments succeed. 6. A real case, from conditional green card to removal and back out. Let's bring this down from policy to something more human. Imagine someone who came to the U.S. years ago as a young student on an F1 visa around 2010. He studied hard, got into medical school, later married a U.S. citizen. His U.S. citizen spouse filed a family petition, I-130. He applied for adjustment of status, I-485. He was approved and given a 2-year conditional green card. For a while, life looked straightforward. Then the marriage began to fall apart. Like many people in this situation, he reached the point where the marriage was no longer viable, but his immigration status still depended on that relationship. He needed to file Form A-751. Why? Not jointly, but as a waiver, asking USCIS to remove the conditions on his green card. Even though the marriage had ended, over several years that I-751 process went very badly. The evidence may have been weak at first. He might not have had a lawyer early on. He filed, was denied, filed again, was denied again. Eventually, USCIS terminated his conditional status, issued a notice to appear. In 2019, placing him into removal, deportation proceedings. But then for years, nothing happened. His case wasn't actually put on the immigration court's active calendar. He went on with life. He eventually remarried. His new U.S. citizen spouse filed a fresh I-130. That I-130 was approved. Then in 2023, out of nowhere, a notice arrived from immigration court. Master calendar hearing scheduled. His case was now officially active. A judge expected him to show up and defend himself against removal. At that point, he hired an attorney. The legal team collected his full history, showed that he now had a valid, approved I-130 through his second marriage, a real lawful path to permanent residence again. They filed a motion asking the court to dismiss his removal proceedings so that he could complete his green card process with USCIS. Instead of fighting a deportation case, he had a clear way to resolve. The judge reviewed the record, considered his life, his ties, his approved petition, agreed. The case was dismissed. He walked out most of removal proceedings and back into the regular USCIS process. Important notes. Outcomes like this are not automatic. Dismissals are getting harder. In today's climate, facts matter, evidence matters, timing matters, professional help matters, but this story reminds us, being placed in removal proceedings is not the same as being deported. There is space now in the system for motions, legal arguments, appeals. How you unlock that space and when must you act can change your future. 7. What you should actually do in 2026. With everything we've covered, Venezuela, travel restrictions, USCIS holds and re-reviews, moratorium talk, TPS lawsuits, detention challenges, and real case examples. What does this mean for manukomias amatiksnian? Here are practical steps if you are an immigrant, a green card holder, a TPS beneficiary, someone with a pending application or court case in 2026. Ussimid Worksheet Wars 1. Treat every government envelope as serious. If you receive mail from USCIS, ICE, the Immigration Court, EOIR, open it, read it. Don't assume it's just a copy or my case is over, so this must not matter. Especially if you are from one of the 39 restricted countries you cannot afford to. Miss a biometrics notice? Miss an interview appointment? Miss a letter saying your case is being reopened or re-reviewed? A missed notice can turn into a denied case, a missed hearing, an in absentia removal order, all without you even realizing what happened until it's too late. 2. Keep your address updated everywhere. If you move, file Form AR11 with USCIS. Inform your attorney. If you have a court case, update your address with the court as well, using the EOIR change of address form. Don't rely on post office mail forwarding or telling a friend to collect your mail. The government uses the address on file. If they send a notice there and you've moved without updating, you are the one who pays the price. 3. Know your current status. Too many people are unsure whether their case is still pending. It was denied and referred to court. A notice to appear has already been issued against them. If you're not sure, check your USCIS case status online. Call the Immigration Court hotline if you have an A number and suspect you may be in proceedings. If this is confusing, seek help from a reputable immigration attorney, a trusted nonprofit, or legal clinic. Knowing your status is the first step to planning your next move. 4. Do not sit on denials. If USCIS denies your I-485 green card, your I-751 removal of conditions, your asylum application and the notice mentions a monun notice to appear, possible referral to immigration court, that is not just another letter, it's a warning. Your next chapter may be in court. Doing nothing for months or years shrinks your options, makes it harder to fix things later. Talk to a qualified lawyer as soon as you can after a denial. Not after you get a hearing notice. 5. If you have TPS, know your dates and your rights. If you have TPS from countries where courts have intervened, such as Honduras, Nepal, Nicaragua, South Sudan, do not assume TPS is safe forever now. Instead, know exactly when your TPS and work authorization expire. File every re-registration on time. Follow updates from reliable legal sources. Not rumor-driven social media court orders can change. You need to stay informed. 6. If someone you love is detained, don't assume it's hopeless. If a family member is picked up by ICE, don't assume no bond is automatic and final. Don't conclude, there's nothing we can do without talking to a lawyer. Judges across the country have shown they are willing to push back when detention policies go too far. They will order bond or release in many individual cases. Time and legal help are critical. The sooner you act, the better. 7. Document your life and ties. Keep copies of approval notices, work permits, tax returns, employment letters, school records, leases and utility bills, marriage and birth certificates. Over time, this paper trail becomes the story you can tell to an officer or a judge. Proof of your ties, your good faith, your contributions. In a system that often reduces people to file numbers, your documentation helps show who you really are. 8. Don't guess. Ask early immigration. Forms, deadlines. Policies are no guess, a place for guesswork. Asking a question. Early mocks about asylum, TPS, travel under a ban, mandamus lawsuits, motions to reopen. Marriage-based options after a divorce is almost always safer, cheaper, more effective than trying to rescue a disaster months or years later. 8. Closing. You are not powerless. If all of this feels heavy, that's normal. Immigration in 2026 is not simple. We are dealing with new travel restrictions, internal USCIS holds and re-reviews, talk of moratoriums in Congress, TPS terminations and court battles, aggressive detention in some cases, people who have been here a decade or more suddenly being pulled into removal or losing protections. It can feel like the ground is shifting under your feet, but you are not powerless. You are not pawned alone. Millions of people are walking through the same uncertainty. Remember, information is power. The more clearly you understand the rules that apply to you, the less they can ambush you. Action beats fear. Opening the envelope, checking your status, making a consultation, organizing your documents. These are small steps, but they move you from panic toward control. If this explanation from Immigration Updates Hub helped you see the bigger picture more clearly, share it with someone who is scared or confused right now. Honest, accurate information is one of the few things that genuinely reduces fear. And if you want more calm, step-by-step explanations instead of rumors and shouting, stay connected to trustworthy sources, whether that's Immigration Updates Hub, a legal newsletter, or a local nonprofit you trust. We can't stop every policy change that comes out of Washington, but we can refuse to walk through those changes in the dark. Stay informed, stay patient, and most importantly, protect your status and your future.